지금부터 2022 국제 특허법원 콘퍼런스 1세션을 바로 시작하겠습니다. 모두 착석해 주시면 감사하겠습니다. Now we shall begin the first session. In this session, we will take time to hear the recent IP trend in global litigations. 네, 이제 1세션을 시작하겠습니다. 네, 자리에 착석해 주시면 감사하겠습니다. 네, 자리에 앉아주시면 감사하겠습니다. Now we shall begin the first session. The moderator of the session 1 is Honorable Chief Presiding Judge 주형문 of the Patent Court. 1세션 진행은 문주형 특허법원 수석판사님께서 맡아주시겠습니다. Please join me in welcoming Ms. Moon. 큰 박수 부탁드리겠습니다.
반갑습니다.
Good morning,
안녕하십니까?
everyone.
오늘 제1세션 사회를
I
맡게
will be
된
moderating the
문주형입니다.
first session. I am
제1세션은
주영문. In the
해외
first
주요
session,
국가와
we will be
우리나라의
examining the
IP
recent
소송의
trends in
최근
IP litigation,
동향을 알아보는
both at home
시간으로
and abroad.
마련했습니다. 제2세션부터
Starting from
시작되는
session
특정
2, we
주제에
will be
관한
discussing
본격적인
very
토론에
specific
앞서
topics.
주요
But before
국가의
doing that,
지식재산권
I believe
관련
it will be quite
새로운
meaningful
제도와
for us to
판례의
look at the
흐름을
new
살펴볼
systems
수
and
있는
trends in court
시간이
precedents
될 것이라
related to the IP
생각합니다.
field that has emerged in recent
현장에
years.
직접 참석해 주신
Aside from
분들
those of us
외에도
here at the
지금
venue physically,
온라인으로
there are also many people
여러분들께서
joining the
함께하고
conference
계십니다.
via online.
모든 분들에게 이번
So,
세션이
I hope
국제적
this session
IP
will
소송
prove to
동향을
be fruitful
전해드리는
for
귀한
all of
시간이
us in
되기를
expanding our
기대합니다.
understanding of the international trends in IP litigation.
발표에 앞서
So
제1세션의
before starting with the
패널들을 소개해
presentations, let me
드리겠습니다.
introduce the panels for the first session.
먼저 독일
First,
미헨
from
제1지방법원
Germany, we have
안나
with us
레나 클라인
Judge Anna Lena
판사님이십니다.
Klein from the
클라인
Munich District
판사님은
Court Number 1.
2018년 이후
Judge Klein has served in
지식재산권법
various
분야에서
positions in the IP
다양한
field
직위를
since
맡고 계시고
2018 and
제4세션 및
also
모의
will be
중재에도
taking
참여해
part in the
주실
fourth session as
예정입니다.
well as the moot trial.
다음으로 호주
Next,
연방법원
from
존
Sydney,
니콜라스
we have with us Judge
판사님이십니다.
Nicholas from the Australian
판사님께서는
Federal Court.
2009년부터
Judge
호주
Nicholas
연방법원
was
판사로
appointed
임명되어
as
분리된 유전 물질의 특허
Federal
적법
Court judge in
적격성 등
Australia and has
다양한
passed judgments on
지식재산 관련
various IP-related
판결을
cases,
선고하셨습니다.
including the patentability of
이어
separated gene
전 미국
materials.
연방
And
순회
we also have with
항소법원
us in this session
캐틀린
Judge
오말리
Caroline
판사님이십니다.
O'Malley, former
오말리
judge
전
of the U.S.
판사님께서는
Federal Circuit
27년
Court.
이상
Judge
미
O'Malley has
연방법원
served for more
판사로
than 27
재직하시면서
years as a federal court judge in the United
지식재산권법
States
분야
and has been
발전에
leading the development
힘쓰셨습니다.
of the IP
마지막으로
litigation
한국
field.
특허법원의
And finally,
박은희
we have with
판사님이십니다.
us Judge Park Eun-hee from the Korean Patent Court.
이제 제1세션으로 본격적으로
We will
들어가도록
now
하겠습니다.
start the first session.
제1세션에서는 크게 4가지 주제를
In
다룰
the first session,
예정입니다.
we will be
첫
dealing with
번째 주제는
4
각국
topics.
지식재산권법
The first
분야
topic is the recently
최근
adopted
도입된
systems
제도
in your
소개입니다.
country's IP field.
두 번째
The second
주제는
topic
각국의
is
최근
the interesting
지식재산권법
court
분야
precedents that
흥미로운
came out
판례
recently in
소개입니다.
the IP
세
litigations.
번째 주제는
Third
현재
topic is
진행
the key
중이거나
issues that are
향후
underway
쟁점화
at
될
present
것으로
or
보이는
issues that may
지식재산권법 분야의
potentially
주요
become important
쟁점입니다.
going forward.
독일 개별 질문으로
And as a separate question to
유럽
Germany,
통합
we would like to
특허법원
ask about the
협정에
issues
관련된 여러
surrounding
쟁점에 관한 소개도
the
부탁드렸습니다.
United Patent
네
Court
번째
in Europe.
주제는
The
팬데믹 이후
fourth
IP 소송 및
topic is
재판 절차
changes
등에
related to the IP proceeding
생긴
and
변화
trial
소개입니다.
procedures that took place after the pandemic.
위각 주제에 대한 패널들의 자세한 답변은
The
자료실에
detailed answers
실려
of the panels
있으니
for each of these
그것으로
topics is
가름하기로
presented in the
하고
conference booklet. And so
오늘
today, the
패널들께서는
panels
각자가
can
중요하다고
talk about
생각하시는
those
점에
issues
관하여
for
13분 정도에 걸쳐
around
소개하도록
13
하겠습니다.
minutes.
먼저 첫 패널을 모셔보겠습니다.
First, I would like to
미국의
invite
캐틀린 오말리 전
our
연방
first presenter,
손해법원
Judge
순회
O'Malley from the United
판사님께
States, to
발표를
make her
부탁드리겠습니다.
presentations.
오말리 전
Judge
판사님 연결해
O'Malley,
보겠습니다.
the floor is
오말리
yours.
전 판사님.
Thank you. I'd like to say good morning to you. It's evening for me, but I know it's morning for you. So good morning. I wish I were there in person. I still have fond memories of the last time I visited the Korean Patent Court with members of the Federal Circuit, and I look forward to doing so again at some point in the future. I'm happy to join my fellow panelists for a discussion of these thoughtful questions. I'm looking forward to hearing our respective approaches to them. I refer you to my written submission for details and case citations, but in the limited time allotted to me, I'd like to approach these questions with the big picture in mind, the health of the US patent ecosystem. The US patent system dates back to the inception of our country. The grant of an exclusive right to practice one's inventions, writings, and creations appears in our Constitution. Our founding fathers believed that the promise of enforceable patent rights would encourage innovation, and that innovation would spur growth that would in turn help secure our economic and political independence. The concept was, and in my view remains, a sound one. Determining how to put the concept into practice and adapt those practices to changing technologies and increasingly global economy has not always been easy. Congress revised our patent system several times between 1790 and today as we attempted to adapt to technological changes and the concerns of stakeholders. But the most dramatic adjustment, even more dramatic than the creation of the Federal Circuit in my view, was the passage of the America Invents Act in 2011 and the creation of an inter partes review system. Before that, with few exceptions, such as reexamination proceedings, the Patent Office granted patents, and it was the province of the courts to enforce and define the rights granted in those patents, and to assess patent validity with the benefit of a more detailed record of the invention and the state of the art than available to examiners. Because our patent system consciously allowed patent owners not to practice their patents and to instead license them, sell them, or merely possess them, those wanting to make or sell products in a given space began to see patents and non-practicing patent owners as roadblocks to innovation. And because our Constitution also granted patent owners a right to a jury trial in infringement proceedings, and the invalidity challenges asserted as defense to those proceedings, litigation itself was seen as hampering innovation. That was the genesis of the IPR proceedings, designed to provide a fast, less expensive alternative for challenging patents by allowing patent challenges to proceed before administrative judges rather than district courts. While IPRs are controversial, a topic that needs to be saved for another day, no one can debate that the development and implementation of the IPR process has been impactful. Statistics show that the vast majority of the requests to institute IPRs come from only a handful of large tech companies, that the vast majorities of those requests are granted, and that a substantial majority of the claims challenged in IPRs are invalidated. In other words, many patents, especially those granted to smaller independent inventors, indeed most awarded to those inventors, are successfully challenged even after businesses have been built on the promise of those patents. The fact that there is no standing requirement for requesting IPRs, that the threshold for invalidating claims is by mere preponderance of the evidence, and that there is no presumption of validity afforded to issue patents in IPRs make patent challenges at the PTO much easier to sustain than those in district court. While legislative proposals have been floated to try to change the IPR process, it is not likely any of those will succeed. So patents will continue to fall in this system. Moving to the second and third questions, those regarding new cases and likely contested areas of law in the US. I'm going to address them together because it is the most recent changes in the law that have spurred the most debate. I'm going to mention two topics: patentable subject matter and invalidation of patents under 35 USC section 112 on enablement and written description grounds. Both developments in the law have resulted in the invalidation of broad categories of patents previously thought patentable. As for eligibility, the Bilski v. Kapos and Alice v. CLS Bank cases have rendered most computer implemented business methods unpatentable, providing a bleak outlook for the protectability of AI-related developments in the future. Indeed, the abstract idea concept discussed in those cases has been used to invalidate many patents that involve computer-implemented improvements to technology that extend well beyond the business method systems. The Mayo and Myriad cases, for their part, render virtually all diagnostic methods and all efforts at gene editing likely unpatentable. Despite substantial confusion and controversy surrounding the tests laid out in these Supreme Court decisions and a sustained call for greater clarity, neither the Supreme Court nor our Congress have yet to respond. The changes in the 112 space are more recent, but no less concerning, at least to me, because they make it easier to invalidate patents on important developments, especially those relating to biopharma advances. As to enablement, many argue that the Federal Circuit requires more from patent specifications than the statute, especially in unpredictable sciences. Indeed, just yesterday, the Supreme Court granted certiorari in Amgen versus Sanofi to consider whether a patent specification must teach a skilled artisan precisely how to practice the full scope of an invention without undue experimentation, rather than simply allow skilled artisans to make and use the invention as the statute says. Those concerned with the Federal Circuit's use of written description requirement to invalidate claims have not had as much success in convincing the Supreme Court to step in. The Supreme Court denied cert in the Biogen and Novartis cases mentioned in my written materials in recent weeks, and just today denied cert in the Juno case. Many contend that this 112 trend at the Federal Circuit, unchecked by the Supreme Court, will mark the death of genus claims in the biopharmaceutical space and make it increasingly difficult to prosecute or maintain patents on new biopharma advances. All of these developments, in my view, bode poorly for the future of the patent system in the US and its ability to spur the creative innovation the founders hoped to encourage. It seems to me that we are headed in the wrong direction in this country, and I'm happy to hear, even from the presentations that we heard already this morning, that several other entities are proposing that we head in a different direction. While reforms were admittedly needed in the US, I fear that we have gone too far. I feel better about the question posed in question 4, however, and that is, how have we adapted to the pandemic? In the US, I believe the courts have adapted very well, while recognizing the importance of open courts and access to the courts. The Federal Circuit immediately responded to the pandemic by adopting a system for conducting patent cases virtually through live streaming of audio streaming. We had to allow for additional changes in the court system that did not normally allow cameras in the courtroom, though, to allot for, to change those in order so that we could conduct trials virtually. For bench trials and for civil trials, it was a lot easier because we were able to quickly adapt to the system and allow for bench trials to be done virtually, even with witnesses from across the world. And we eventually allotted for civil trials fully to be done virtually, even with juries. The criminal trial process is more difficult because of a defendant's right to appear And that's a question that needs to be addressed with consent. But I believe our court system responded very quickly and very aggressively to the concerns that the pandemic presented. And I believe that a lot of those practices will remain in effect going forward, especially allowing for live streaming of hearings at the appellate stage throughout the country, allowing the public to participate in proceedings that they weren't otherwise given access to. So I'm going to turn now to the next of our colleagues to allow them to address their issues.
네, 오말리 전 판사님 감사합니다.
Thank you, Judge O'Malley. Thank you very much.
판사님께서는
Judge O'Malley
미국에서
explained
2012년
how in the
9월
United States
도입된
in September
당사자에게
2012,
무효심판
the IPR
IPR
patent
제도에 관해서
invalidation
상세하게
trial
소개를
was
해주셨고요.
introduced, and
특히 의학 특허
also about the
발명의
recent
특허성에
decisions
관련된
related
최근의 판결 경향에
to
대한
the medical
말씀도
drug
해주셨습니다.
patents
아울러
related decisions.
화상 배심 재판에 관한
And
소개도
also, there
해주셨습니다.
was instruction
대단히
about the
감사합니다.
virtual jury trial
다음으로 미넨
that was introduced to the United
제1지방법원
States.
안나 레나 클라인
Next, we would
판사님을
like to
연결해 보겠습니다.
invite
판사님,
Judge Klein from
네,
Munich.
판사님, 제 소리 들리나요?
Judge Klein, can you hear me?
판사님,
I can hear
반갑습니다.
you fine. Thank you very much. Can you hear me?
네네, 잘 들립니다.
Yes, we can hear you
네,
very well.
감사합니다.
Thank you
판사님,
so much.
네,
Good morning to Korea. It's indeed a very early morning today here in Munich right now. It's about 3 o'clock in the morning, so quite early.
네,
Thank you very much for organizing this really fine conference. Thank you for inviting me. And I'm really happy to participate in this very fine conference, at least if not in person, via my computer. So thank you very much for having me. As to newly adopted systems in Germany, actually our Patent Act, our German Patent Act, was amended only last year. Some provisions came into force directly in 21, and some provisions only entered into force this year. Actually, I think many of those provisions that have been amended will have a great impact on the infringement cases that we are dealing with. Most important for infringement cases is probably that courts are now allowed to refrain from ordering an injunction based on disproportionality aspects. So we see a lot of disproportionality defenses now in our infringement cases, and I will go back to that tomorrow in greater detail because it really has a lot of impact on our infringement cases. So I will deal with that in greater detail tomorrow in session 4. Secondly, the amendment tries to heighten the synchronization between validity cases and also infringement cases. You might know that in Germany, we have a bifurcation system. So my court, we only deal with infringement cases, while the validity issues are decided at the patent court. And we only decide in our infringement cases if we need to state our infringement case based on validity issues raised at my court and raised and to be decided at the patent court, so later on. Sometimes the infringement cases are decided, well, much sooner than the validity cases. So we have a time gap, and we call this usually an injunction gap because we usually order injunctions in infringement cases. So to address this issue of injunction gap, the legislator decided that the patent court shall give out a communication after 6 months after serving of the invalidity action. So the infringement court shall have some kind of basis to decide on, some support from the patent court to decide when we decide if we're staying in the case or not. So this should help us. We do not see the effects as of yet because those provisions only entered into force this year. So it's really newly adopted. But I guess the impact might be quite high actually. And thirdly, also very important, the issue of the protection of trade secret has been introduced into the Patents Act. And this, we do get a lot of requests for protection of trade secrets. And this is very important for both sides if they feel that they have to decide between either disclosing trade secrets or not being able to defend themselves. So in these cases where parties have to disclose trade secrets to defend themselves, this is a very, very important tool. And now we have a system how to address trade secrets in court and how to deal with those. This is very important, actually. It is especially important in friend cases, not only, but very much important in friend cases. And I will get to my next subject, precedents in IP cases. So friend has been a major issue in German litigation, and it remains to do so. We have a lot of cases dealing with friend, and it's a very important subject for us. Obviously, I cannot go into all the details of friend right now, but I will give you some aspects which I find are very interesting and hotly debated right now in Germany. So we, of course, as our legal background, we have the decision of the CJEU in Huawei versus ZTE, which he took in 2015. And in Germany, we also have two decisions from the Federal Court of Justice, Friend Defense 1 and 2. Those are the legal background that we all deal with in Germany. The Federal Court of Justice, in the wake of the CJEU decision, really stressed the importance of the infringer to be willing to take a license. He must be a willing licensee. And this is what the courts in Germany focus on right now when deciding friend cases. We had several decisions taken by different infringement courts, and you may go back to my written statements to see some of those. And for instance, the Higher Regional Court of Düsseldorf and the Higher Regional Court of Karlsruhe both stresses with the Federal Court of Justice the absolute importance of the infringer to be willing to take a license. Of course, we don't have a definition of this willingness. This would make our life much easier. We have to decide in each and every case anew, based on the specific circumstances of the case, if the infringer was actually willing to take a license. We can only look at case law to get some inkling of what this willingness to take a license might contain. And so I'd like to mention some of those aspects, like I said. It's very important that these declaration to take a license, a willingness to take a license, may not be just a lip service. The infringer must really act upon this declaration and must fill this declaration with life. So if we see further action or acts that would not relate to his declared willingness to take a license, the courts may deem the infringer unwilling after all, even though he declared some willingness to take a license. And this, for instance, has been stated by the Higher Regional Court of Düsseldorf, also Higher Regional Court of Karlsruhe. The Higher Regional Court of Karlsruhe, for instance, also underlined that it's very important to look at what reasonable parties would do. And what they would do is, if, for instance, the infringer gets an offer, then they would try to get a license deal done. And to get this done, they would put all the change requests they have for a certain offer onto the table at once. So what we sometimes see in litigation is that the infringer only mentions some complaints against an offer before going to court, and then during court proceedings we see several complaints being brought up peu à peu. And this is not what reasonable parties would do. They would get everything on the table at once to really get a settlement done. So the Higher Regional Court of Karlsruhe, for instance, decided that if the infringer gets an offer and then discusses several clauses with the patent holder, and then after only 2 years, or 2 years of negotiations, obviously, the infringer would like to request a totally new calculation method for a license rate, this might be deemed unwilling, deem the unwillingness of the licensee, because usually if you really want to address the groundbreaking calculation method for license rate, you would do so in the very first beginning, for instance. Also, my court, the Regional Court of Munich 1, had several cases relating to France decided this year, and we have several more that are coming this year, next year. And for instance, we also stressed the importance of the of getting everything on the table at once. And we, for instance, decided that if there's a counteroffer, and the counteroffer is made only 5 months after the initial offer, although the way to actually calculate the license rate is very easy, this 5-month time gap might be too high. So again, the licensee, the infringer, might be deemed an unwilling licensee. Of course, obviously, friend litigation is very complex, and those cases are very complicated. So I could only, in the limited time here, delve into some very specifics. But I guess it's a very important aspect, this willingness to take a license. It will be very interesting to see how the Unified Patent Court actually addresses friend. And with that, I come to my third topic, new systems that will be adopted. The Unified Patent Court, I guess that you're basically familiar with the fact that we will have a new court system in Europe next year, beginning as of April 23. The Unified Patent Court will be a supranational court, and it will have certain chambers in all over Europe, in up to 17 member states right now. The UPC will have jurisdiction to decide special cases, for instance, infringement cases, declaration of non-infringement cases, also validity issues. They will decide on patents with unitary effect. This is a new system of patents. I will get back to that in a second. But they will also decide on European patents if those European patents are not opted out of the UPC system. This opting out system is only available for a limited amount of time. The UPC will be bound by different sources of law, and one of the major sources of law is the Unified Patent Court Agreement, the UPCA. The UPCA addresses the organization of the court, the establishment of the court, obviously, but it also contains provisions relating to substantive law. And I will get also back on that. So we will have a whole new court system with whole new legal provisions that have never been interpreted, and they will start to be interpreted next year, as of April 23, when the UPC will finally start working, like I said. So how will the UPC and the UPCA change the patent system and the patent litigation system? First, applications for patents. Applications for patents will still be filed with the EPO. The EPO will examine those applications, and they will also decide on the grant of a patent, or they will decide if the patent is not to be granted. Then, come April 23, the patent holder can decide if they want to have a unitary effect for those European patents that have been granted, newly granted in 23. So this would mean a patent with a unitary effect would mean that the patent would be valid in all the 17 member states of the UPCA, and would also mean that the UPC would have jurisdiction automatically, no opt-out system. But the patent holder can also decide that they want to settle and just have a normal European patent, where they can decide in which countries they want to validate the patent. And then they need to decide again if they want to opt out of the UPC system or stay within the UPC system. So I guess many patent holders right now are thinking about, or have been thinking about, this opting out of the UPC system. It's a very important step for patent holders to take. Concerning litigation, the most important aspect will be that a decision taken by the UPC, for instance, relating to infringement, will be valid and enforceable in all the member states. What we see right now is that we have, in international cases, a lot of parallel proceedings. So we have proceedings in Germany, in England, and in the Netherlands, maybe in Italy and France. This will be made more efficient because you just have one infringement case valid for all those member states. Same goes for validity issues. Those will be decided by the UPC on a one-time basis. Concerning the German system, like I said, we have a bifurcation system, and in the UPC system, basically the courts will be able to decide both on infringement and validity issues if they decide to do so. They have the option of giving the validity issues to another entity of the court, but they may also decide to get a technical judge as support and then decide the technical issues as well, the validity issues. And I guess in many cases, actually, the courts will decide that they will deal with both the infringement and the validity issues at once. So the bifurcation system will not be abolished at the UPC, but at least diminished. A very important aspect, I think. Now, major issues at the UPC. Of course, there will be a lot of questions arising at the UPC because, like I said, we have a totally new system, a totally new law that will be in force and has never been decided on. So a lot of issues will be raised. One very important aspect that has been debated hotly over the last year or two in Germany is the question of injunction again. And some former speakers also said injunction is a very important aspect right now. So I guess the question will be if injunctions are ordered automatically, more or less automatically by the UPC, or if injunctions will be dealt with on a discretionary basis by the court. I can only give you the sum up here, but in my opinion, this is my personal opinion, I cannot bind the UPC in any way. I would think that the UPC might have some discretion, but they will actually take this discretion as well. Automatically, they would order an injunction and only use this discretion in really exceptional cases. For instance, disproportionality issues. Like I said, we get back to that tomorrow. Very interesting discussion. So the patent court, the Unified Patent Court, took a long time to come, actually a whole decade since the UPCA was first signed by some member states. But the list of judges who will be present at the UPC, who will be UPC judges, is quite impressive. Those are very highly regarded, exceptional judges. So I guess once the UPC is actually working, it will be a very, very fine court. With that, briefly onto my last subject, adjustments after the pandemic. Actually, it's totally normal for my court right now to have digital hearings, hybrid hearings, at least every other week, usually every week. Parties adapted really well to our new systems of having video calls, video conferences, and it's very convenient, I guess, from parties from overseas, from Asia, from the US, to just dial in, have an interpreter dialed into the video call as well, so they don't have to travel to Germany and don't have to spend the time and the money. They still get all the information that they need to get from our courts. So it's very good. We actually had all the provisions to do digital hearings in place before the pandemic, but before nobody used it because it was deemed to be very uncomfortable for the judges. So it was very seldomly used, those provisions. But with the pandemic, obviously, we had to make use of those provisions, and it worked out really, really well, I say. I'm a mediator as well, and also in mediations, I've had successful digital mediation meetings with a settlement in the end. Nobody would have thought it possible before the pandemic that you could do a mediation via computer, but it's actually possible. So I think, like Judge O'Malley just said, I think this will stay with us, and this is at least something good that came of the pandemic. With that, I leave the floor to the next speaker. Thank you again very much for having me. I'm very grateful to be part of this very fine conference. Thank you so much.
네, 클라인 판사님 대단히 감사합니다.
Judge Klein, thank you so much for your presentation.
2차 개정 특허법
She has covered the Second Amendment to the Patent Act in 2021 and the FRAND agreement, CJEU ruling, and the cases of the Federal Court of Germany, and the points about UPC that will be launched next year, and also how online proceedings are being used for a broad scope, including the arbitration proceedings. And next, we have Justice John Nicholas.
판사님.
The floor is yours.
판사님.
Thank you,
네, 대단히
Judge Mon.
반갑습니다.
Can you hear
Great
and
to
see
see
me?
you.
네,
Thank you.
네, 잘 들립니다.
We can hear you very
Well,
well.
네, 소개해
thank you very
주시기
much.
바랍니다.
Look, it's a great pleasure to be participating in this conference. And before I start, may I wish you a very successful and enjoyable conference. I'm sure it will be that. So let me begin. And due to limitations of time and due to the fact that I think really there have been no significant legislative changes in Australia in the IP field over the last couple of years, I'll move straight to questions 2 and 3, or topics 2 and 3, which I will deal with together. And what I wanted to do was talk about 2 or 3 significant cases in Australia that have been decided in the last 12 months, most of which are concerned with the issue of patentability. And in the case of the first matter I wanted to discuss, the question of whether an artificial intelligence can be an inventor. So earlier this year, the full court of the Federal Court of Australia delivered a judgment in a case called Thaler. The same individual involved in that case was involved in similar proceedings heard in the United Kingdom. And the court in Australia held that under the Patents Act, an inventor must be a natural person. The question in the appeal was whether an artificial intelligence machine could be considered an inventor. The judge whose decision was the subject of appeal was a very experienced judge with a very deep and long-standing understanding of science and technology. And he held that an inventor need not be a natural person. Now that decision came as a surprise to many practitioners here in Australia. His Honour analysed in detail how artificial intelligence works, or sometimes works, and in particular how it had been utilised in pharmaceutical research. And he concluded that no, and I quote, no narrow view should be taken as to the concept of inventor. And to do so would inhibit innovation, not just in the field of computer science, but all other scientific fields which may benefit from the output of an artificial intelligence system. Now, the way the question arose in that case was itself interesting. The relevant regulations required that the patent applicant nominate the inventor in the patent application. And the Commissioner of Patents was of the view that the relevant regulation could not be complied with because it was legally impossible for an artificial intelligence machine to be an inventor. Accordingly, she concluded that the requirements of the regulation had not been met and the patent application must for that reason be rejected. Now in the full court, and I was one of the 5 members of the full court, there's considerable attention given to the terms of the relevant legislation and the regulation. But it's not my intention here to spend any time on that matter. What's important at a high level is that the court considered that the identification of the inventor was of central importance to the operation of the Patents Act, as it is closely related to concepts material to the validity of patents and patents, including the right of an inventor to apply for a patent and the right of an inventor to be granted a patent in his or her name. The court noted that the development of patent law had not until now been confronted with the question of whether or not an inventor may be other than a natural person. But it did refer to previous authorities in Australia that proceeded on the assumption that only a natural person could be an inventor, including statements in decisions of our High Court referring to the need for an invention to have been brought about by some human action, giving rise to an artificially created state of affairs. And some of you will be familiar with one of those cases, the most important of which was the NRDC case in the High Court. The full court hearing this appeal also noted that there are important matters that may need to be considered in the context of artificial intelligence and inventions which are not presently addressed by the Patents Act. They include, one, whether as a matter of policy an inventor should include an artificial intelligence. Two, whether a patent should be granted for an invention created by an to whom a patent should be granted for an invention created by an artificial intelligence. And three, whether the inventive step requirement should be differently dealt with for an invention created by an artificial intelligence compared to a natural person. Now, as to that second matter, who's entitled to the grant of the patent, the available options could include the owner of the machine upon which the artificial intelligence software runs, the developer of the artificial intelligence software, the owner of the intellectual property in the artificial intelligence software, the person who inputs the data used by the artificial intelligence to create the invention, and there are still other possibilities or permutations of those possibilities available. So the primary judge's decision was overturned, and the full court concluded that an artificial intelligence, under the legislation that presently stands in Australia, cannot be an inventor, and therefore a patent can't be granted in respect of an invention made by an artificial intelligence. Another issue that is highly topical in Australia concerns what we often refer to as computer implemented inventions. And I know Judge O'Malley touched on this briefly in her remarks. To understand the present state of the debate in Australia concerning the patentability of computer implemented inventions, it's necessary to provide some background to the requirement under Australian law that there be a manner of manufacture. Our Act relevantly provides that for an invention to be patentable, the invention must be for a manner of manufacture. And those of you who are familiar with the older law in the United Kingdom would be well and truly familiar with that concept. There are many settled categories of invention that are not patentable because they do not constitute a manner of manufacture, as that concept has been developed in the case law. Claims to mere abstract ideas or information are not patentable. This would include claims to schemes or plans for the indexing, coding, or presentation of information, or schemes concerned with time management, production sequencing, and traffic management. Similarly, a scheme for arranging assets so as to protect them from creditors, an interesting one indeed, has been held in Australia not to be patentable on the basis that it did not give rise to the necessary artificial state of affairs or artificial effect that the authorities require of an invention if it is to satisfy the manner of manufacture requirement. Now, things have become more complicated, as you're all aware, as more and more patent applicants have sought to protect business schemes or business methods that are computer implemented. We have had a number of cases in Australia concerned with investment schemes, for example. One of those cases concerned a scheme for compiling a weighted index of publicly listed securities. If what was described in the patent specification was no more than a mere description of how to create the index, then there would be no question that the scheme would not be patentable. However, the issue was whether a requirement in the claims that the scheme be computer implemented made a difference to the result. It was held that the fact that this investment scheme was computer implemented did not render it patentable, as this was insufficient to meet the requirement that the invention produce a relevant artificial effect. Now that's some background to a recent decision of my own earlier this year in a case involving the fitness business known as F45 training or F45. Some of you may be familiar with its operations. The claims of the patents in issue in that case were directed to a computer implemented method for configuring and operating a number of fitness studios. The essential idea was that each studio would have a series of numbered workstations arranged on the studio floor at which different exercises would be performed. Customers of the studio would perform an exercise at one station before moving to another station at which they would perform a different exercise, and so on. They were provided with instructions as to what exercise to perform and for how long. For example, how many repetitions of a certain exercise to perform, when and for how long to rest, and when to move to the next station. The invention was described as being computer implemented, and the specification of the claims described in some detail a network of computers, servers, and associated databases configured so as to enable the instructions to be transmitted from a central controller located in a centralized control room to the various fitness studios, possibly in quite remote locations, and to the exercise stations at which a monitor displayed relevant instructions and played relevant audio in those studios. Now, one of the arguments that F45 raised in support of its patents was that the patent was not to a mere scheme because the implementation of the invention in accordance with the requirements of the claim contemplated not just the use of computer technology, which I think it was accepted was fairly generic or conventional, but also the physical configuration of the various exercise stations in accordance with the scheme. However, as I said in my judgment in that case, I quote, the mere fact that the invention contemplates that exercise stations be physically configured with fitness equipment is not in itself sufficient to result in the required artificially created state of affairs, any more than would a scheme for the layout or configuration of a sports field or a children's playground, which is changed periodically to take account of the systems. It's the kind of scheme that has historically never been regarded as patentable subject matter. The scheme is not made patentable merely because it is implemented using generic computer technology. A more difficult problem that has now arisen in Australia concerns gaming technology. In Aristocrat and the Commissioner of Patents, the full court of the Federal Court was dealing with an appeal in a case allowing the grant of a patent over the objection of the Commissioner of Patents to an electronic gaming machine, or what's sometimes called a poker machine. The majority of the full court held that the substance of the invention was a computer program embodying a scheme or a set of rules for the playing of a game, which was not patentable, and which was not made patentable by the fact that it was implemented using computer technology. It is apparent from the majority's reasons that they considered that the method of implementation could only confer patentability if it involved an advance in computer technology. Now, that aspect of the majority's decision caused some disquiet amongst the profession. The problem is that it may be asking too much for the patentee, or at the application stage, the patent applicant, to show that the invention involves an improvement in computer technology. There may be some advance in the field of technology to which the invention is primarily directed. In that case, the field of gaming technology, even though a computer scientist may not agree that the relevant improvement amounts to an advance in computer technology. An example given in my minority judgment was of a computer implemented scheme or idea for the running of a refrigerator in a more energy efficient way. For example, involving a new and different algorithm. It may be patentable, even though the relevant technological advance resides in the scheme or idea rather than the working of the computer with which the scheme or idea is implemented. If the result of the contribution of the refrigeration engineer who wrote the algorithm and the computer engineer who implemented using everyday computer technology is a more energy efficient refrigeration system, then the invention may well be patentable, even though the technological advance resides in the field of refrigeration technology rather than computer technology. Similarly, in the case of gaming machines, patentable subject matter may be found to exist in the way in which the gaming machine functions, even though a computer scientist may not consider that there has been any advance in the field of computer technology. In my note to the organisers of this conference, I indicated that by today, the appeal from the full court of the Federal Court of Australia in that case, the Aristocrat case, would have been heard and determined by the High Court of Australia. And I expected its decision would settle the question of whether it was necessary in the case of computer implemented schemes or games to establish that the relevant invention involved an advance in computer technology. That appeal was heard by a full bench of our High Court of Australia, comprising 7 judges. I'm sorry, it was to be heard by 7 judges. As it happened, one of the judges was indisposed, so the appeal proceeded only with 6 judges sitting. The result in the High Court was that 3 judges held that the invention was not patentable, and 3 judges held that it was patentable. So it was a split decision. A division of opinion of that kind, which automatically results in the affirmation of the judgment under appeal, has only happened once or twice in the court's history. But the result is the High Court's judgment on the issues has not settled a number of important questions surrounding the patentability of these kinds of inventions. However, it does appear from what both the majority and the minority judgments, I should say, the 2 sets of reasons in the High Court, that the High Court's unlikely to adopt the majority test, the majority in the full court test requiring that there be some advance in computer technology. They're the cases I wanted to briefly talk about. In relation to the impact of the pandemic and the use of technology, I can be brief. I've said something about this, which is reported in the printed materials. We've found that the experience has been very favourable because it has really helped develop and enhance our ability to run trials and online, which we're now doing, including receiving evidence in chief and evidence in cross-examination and evidence in concurrent sessions, usually given by experts. And it's been incredibly effective and well received by the profession. And it's also led to a great reduction in costs in many cases, because once upon a time there was a lot of travel engaged in by people, and you can imagine that where we are located in Australia, even internally, people are required to fly from one city to another and stay overnight very often, and they may end up spending only a very brief time in court. So that has been a great development from a range of perspectives, and the court and the profession have been very pleased with the outcome thus far. So thank you very much, Judge Munn.
존 니콜라스 판사님 대단히 감사합니다. 니콜라스 판사님께서는 AI가 특허 발명의 발명자가 될 수 있는지, 컴퓨터 구현 발명의 특허적 적격성 등에 관하여 좋은 판결 소개해 주셨습니다. 마지막으로 한국의 박은희
And also the computer implemented invention case precedents
안녕하세요.
have been
대한민국
introduced.
특허법원
Next,
박은희
Judge Baguni
판사입니다.
from Korea.
먼저 대한민국의 지식재산권 관련 분야에 새로 도입된 제도를 설명드리겠습니다.
First,
상품
I would
또는
like
상품의
to
포장에
explain about the
상표를
newly
표시한
adopted
것을
system in the field of
전기통신을
IP
통하여
rights in Korea.
제공하는 행위
Provisions that
또는
punish a
이를
crime of
목적으로
infringement of a patent
전시하거나
design or
수출을
exclusive
수입하는
license
행위가
thereof used to prescribe that such offense
상표의
shall be
사용에
subject
해당한다는
to a
내용의
complaint, but were
상표법 개정이
revised such that a
이루어졌습니다.
crime should not be
그리고
prosecuted against
데이터를
objection.
부정하게 사용하는
And
행위와
also,
유명인의
to
표상,
assist
성명 등
the
타인을
Intellectual
식별할 수
Property
있는
Trial and
특기를
Appeal Board in better
공정한 선거대
utilizing expert
관행이나
knowledge,
경쟁 질서에
the
반하는
Patent Act
방법으로
allowed experts to
자신의
develop
영업을
appeals to
위하여
engage as
무단으로
technical
사용함으로써
advisors.
타인의 경제적 이익을
And
침해하는 행위를
also,
부정경쟁 행위로 금지하는
the
내용의 개정이
infringement
이루어졌습니다.
of portrait and other rights
다음으로
of
지식재산권
and the
관련
economic rights
최신 판례를 몇
of other
가지만
persons were
소개하여
protected
드리도록
under the
하겠습니다.
amended Act.
사용자가 별도의 라이선스를 구입하지
In
않고
this
피고가
case, a
저작권을
user
가지는
purchased
프로그램에
from the plaintiff only
제품
a product key
기만을
of the program at
원고로부터 구입 후에
issue, whose
피고가
copyright holder is the
운영하는
defendant,
사이트에서
and without a
프로그램을
license purchase,
다운로드 받으면서
downloaded the program at issue
원고로부터
from a
구입한
website
제품
operated
키로
by the
인증을
defendant,
받아서
and further
그
consented to the right to
프로그램을
use
사용한
contract while
사건이었습니다.
downloading and use
여기서
the program at
대법원은
issue by
사용자가
obtaining
위와 같이 이 사건
authentication with a product
프로그램을
key.
다운로드하여
The Supreme Court held
복제하는
that the
행위는
user's act of
저작권
downloading
침해에
and copying the
해당하고
program at issue,
제품 키를
as
판매한
stated,
원고의
is
행위는
infringement of
저작권
copyright, and the
침해의
act of
방조에
selling the product key
해당한다고
constitutes
판시하였습니다.
aiding infringement of copyright.
부정경쟁 방지법 제14조의
Article
2 제2항은 부정경쟁 행위로
Clause 2,
영업상의
paragraph 2
이익을
of the Unfair
침해하자가
Competition
침해
Prevention
행위로
Act
이익을 얻은
prescribes that
경우에는
where
그
an
이익액을
infringer of operational
영업상
profit
이익을
is
침해당한
enriched with a
자의
benefit through an act
손해액으로
of unfair
추정한다고
competition, the
정하고
amount of
있습니다.
benefit should be presumed to be the
타인의
amount of damages
손가등을
of a
무단으로
person whose
사용하여
operational profit
완제품을
has been infringed.
제조함으로써
The court ruled that using
손가등을
the outcomes of another
적법하게
person
사용한
without
경우에
permission
대해서
compared to a case in
제조
which the
비용을
outcomes
절감한
of another person are
사안에서
used lawfully,
대법원은
resulting in
이와 같이
savings in
비용
terms of
절감으로
manufacturing
얻은 이익을
finished
침해자의
profits.
이익으로 볼 수도
Therefore,
있다고
any profit
판단하였습니다.
generated by cost saving may be viewed as the infringer's benefit.
발표자가 개인적으로 관심 있게 생각하는 쟁점은 출원 전에 공지된 디자인이 신규성 상실의
Personally, I am
예외에
interested in whether a
해당하여
defense
등록된
of a
경우에
freely
그
exploited
공지된
design
디자인의 기초와
of a third party can be
제3자의
permitted on the
자유실시
ground
디자인
of a
환경이
publicly known
허용될
design
수
under the
있는지에
condition
관한
that
것입니다.
such a design publicly known before
출원 전에
filing
공지된
an application
디자인이
constitutes an
신규성
exception
상실의
to loss
예외에
of
해당하여
novelty.
하는 경우에는 디자인
Even if a
등록은
design of an author who
가능해집니다.
has the right to
하지만
register the
이를
design is
실시한
publicly known
제3자가
before an application for design
출원
registration
전에
is filed, the
공지된
design
디자인에
should not be
기초하여
viewed as a publicly
자유실시
known
디자인
design.
판단을 하는
And this is
것을
called
시
exception to
허용된다면
lack of novelty.
출원 전
Where a
공지된
design is
디자인과
publicly known
동일
before
유사한
an
디자인의
application
실시에
was filed
대해서는
falls under exception to
디자인권을
lack of
행사할 수
novelty.
없게
The
된다는
design may be
점에서 이를
registered.
허용할 수
However, an
있을지
issue arises as
문제됩니다.
to whether third party can argue that an exploited design
이를
constitutes a
허용해야
freely
한다는 견해는
exploited design based on the
출원
design
전에
publicly
이미
known
공공의
before an
영역에
application
놓인
was filed.
디자인을 누구나 자유롭게 실시할 수 있다는 믿음을 가지고 그와 동일 유사하거나
In
그로부터
principle, a
쉽게
design already in the
탐색할 수
public
있는
domain before an
디자인을
application
실시하고
for
있는
design registration
제3자의
is
실시행위에
filed is
대해서
deemed to be publicly known by
그
the applicant
공지된
himself and
디자인이
herself
신규성
and not
상실의
be
예외에 해당하여
may not be
등록되었다는
subject to an
이유로
exclusive
침해를
right
인정한다면
and then thus
그
shall be
제3자는 불축의
able to be
피해를
freely
입게
practiced by
됩니다.
anyone
또한 제3자에게 출원
and
전 공지된
by anyone.
디자인이 신규성
However, strictly
상실의
applying
예외에
such principle
해당하여
of
등록된
novelty and an
것인지
inventive step in
그렇지
creation to the design
않은지를
registration
조사할
can be too
의무를
harsh for
부담시키는
those who have the right to
결과가
register the
발생한다는
design,
것을
which might lead to the degradation of the
그
principle of
근거로 하고
equity.
있습니다. 허용해서는 안 된다는 견해는 출원 전에 공지된 디자인이
Another
신규성
issue
상실의
is that
예외에 해당하여
it may be
등록이
inconsistent with the
되었음에도
purpose of the Design
불구하고 그 출원
Protection
전
Act to
공지된
contribute to the
디자인에
development
기초한
of industries.
자유실시 디자인
In this
환경이
regard, the Design
허용된다면
Protection Act enacted a
신규성
provision
상실의 예외에
prescribing an
해당하여
exception
등록된
to the lack of
디자인은
novelty in
사실상
determining
그와
the
동일
registration
유사한
within a
디자인의
scope
실시에
not
대하여도
harming a
디자인권
third
침해를 주장할
party's
수 없게 되고
interest.
그 결과
If an
등록
exception to lack of novelty
디자인권자로서의
precludes
독점
even a defense of
독자적인
freely
권리를
exploited design
누릴
based
수
on the
없게
publicly known
되므로
design, it would
결국
go against the
신규성
intent of the
상실의
exception
예외를
provision mentioned above,
규정한
promoting
그 법이
equity to the
유명무실하게
extent that it
된다는
does
점을
not harm
근거로 하고
a third
있습니다.
party's interest.
현재까지 이에 대하여 명시적으로 판단한 대법원
We do
판결은
not
찾기
have Supreme Court
어렵습니다.
decisions explicitly
마지막으로
explaining the
팬데믹
above
이후
issue.
대한민국의 소송 및 재판 절차 등의
Finally,
변화,
any
비대면
changes
재판의
in
진행에 관하여
Korea's
소개해 드리도록 하겠습니다.
procedural system and
팬데믹으로 인하여
also the
비대면 소송이
IP-related
일상화되면서
court systems.
비대면 재판에 대한
Korea had
요구도
been
증가하고
allowing
소송
pleadings through
관계인이
virtual
직접
trials
법정에
already.
출석하기
However,
어려운
the
경우
system had been
쉽고
not
편하게
been used
재판
frequently before
절차에 참여할 수
COVID-19. Things have
있도록
changed due to the
2021년
pandemic.
11월
Many
18일부터
activities have become
영상
contactless and the
재판이
demand
확대
for contactless
실시되었습니다.
trials have
영상
increased.
재판은
With this
변론기일,
backdrop,
변론
virtual
준비기일,
trials have been
신문기일,
expanded from November
조정기일,
18,
증인, 감정
2021.
및 당사자
Oral
신문에서
hearing,
가능합니다.
pre-trial hearing, hearing date,
영상 재판
mediation date,
프로그램을
witness,
이용하여
appraiser,
영상
and party
법정에
hearings can be conducted
접속하여
virtually.
재판을 진행할 수 있고
And
사무실, 집, 가까운 법원에서 영상 재판에 참여할 수
so,
있습니다.
in case it is difficult for a party to appear in a court in person due to inconvenience of transportation or other circumstances, for witness and parties hearing, in case it is difficult for a witness to appear in a court in person, if she lives in a remote place with poor transportation, they can make use of the virtual
특히 한국의
trials.
서울중앙지방법원과
Parties and legal
특허법원은
counsels who have
전국의
experienced the
지식재산권
virtual
관련
trial
소송
revealed
소송에
high levels of
관할권을 가지고 있어
satisfaction, mainly because of its
사건
convenience.
관계인의 주도 및
Further, the
거소비가
number
멀리
of
떨어져 있는
applications for
경우가
virtual trials is increasing.
많고
In
특허소송
particular,
사건은
as legal
외국
actions of IP rights
사건과
across the
고도의
country
기술
are under
관련
the
소송의
jurisdiction of the Seoul
증인,
Central District
감정인이
Court and the
외국에
Patent Court,
거주하는
too often
경우가
the courts are
많아서
distant from the
여타의
addresses and the
소송 사건에
residences
비하여
of the
영상
interested
재판의
parties.
필요성 및
In addition,
글씨시로
cases
인한
involving
편의성이
foreign
증대되는
parties
등
or about
장점이
highly
많습니다.
sophisticated
이만 발표를 마치도록
technologies
하겠습니다.
often reside abroad. So this is the reason why the satisfaction level has been so high. With this, I would like to
박은희
conclude my
판사님 좋은
presentation.
발표 대단히 감사합니다.
Thank you, Judge Eunhee Park, for your wonderful remarks. I would like to thank all of our panelists for preparing their answers to important questions. Due to time difference, Judge Annalena Klein is joining us very early in the morning, and Judge Kathleen O'Malley very late at night. They are with us virtually, and Justice John Nicholas joined us and shared very insightful thoughts. I would like to ask your understanding for one point. When I was introducing our panels, there was an error for the flag for Australia. I once again apologize for this error. I'd like to thank once again all our presenters for session 1. And I would like to thank all participants both online and in person. This brings us to close session 1. Thank you so much.
Thank you, everyone. This ends the session 1. Let's give a big round of applause to the moderator and speaker of this session. 큰 박수 부탁드립니다. 패널과 발표자께서는 잠시 무대에서 사진을 좀 찍어주시면 감사하겠습니다.
We will have a photo shoot of the panels for session 1 on stage.
참석자 여러분께서는 1시 30분까지 점심을 드시고 이후 2세션을 시작하겠습니다. 점심은 10분 후부터 제공이 되겠습니다.